morning, everyone, and thank you, Terry. My name is Melanie Patrick Neely. I am the Chief Administrative Law Judge with the Office of Administrative Hearings. I'm excited to be here. Happy Friday. You can move on to the next slide. So I'm going to start with just a quick overview of what an administrative hearing is, because you've probably heard the term, but in terms of the context of Illinois Department of Revenue, I want to just give you a quick overview. So an administrative hearing is definitely a formal judicial proceeding, and it is conducted in accordance with all applicable rules, the administrative procedure rules, and the applicable statutes, as well as the Illinois Rules of Civil Procedure. It is presided over by an administrative law judge, so you would have a full administrative law judge hearing your case, and that same judge would be hearing your case up to and including the finality of that case. All phases of that case are handled by that administrative law judge. And the practice and procedure for those hearings, if you want to look it up, is the Illinois Department of Revenue, which is governed by Title 86, Chapter 1, Part 200 of the Administrative Code. And the process for actually requesting a hearing is governed by 86 Illinois Administrative Code, Section 200-120. You can move on to the next slide. So it's important that you understand that the mission of the Illinois Department of Revenue's Office of Administrative Hearings is very important. It's to timely, fairly, and equitably preside over disputes involving final determinations of tax liability in accordance with all laws and procedures. And I say this because in this time when the rule of law has been called into question, we in the Office of Administrative Hearings enforce that law fairly and equitably, and every single thing we do is going to be in accordance with statute and governing rules. Our administrative law judges, we have currently 5 administrative law judges and a deputy chief administrative law judge who is also hearing cases as well in the Springfield office. They will be one of the judges that you would receive if you file your protest. The chief administrative law judge, myself, I oversee all of the operations and staff of the administrative hearings, and I'm responsible to assign those judges to each case so that when you actually receive a notice that your case has been assigned, you will have been assigned a judge at that time. It's important to know that this process, again, is very fair and equitable, and I make sure and ensure that our judges are governing these cases in accordance with all of these laws and procedures. Next slide, please. And you would ask, what type of cases are heard by the administrative law judges? Well, pursuant to statute, as I mentioned, our jurisdiction, IDOR's jurisdiction, is limited to protests of final notices of tax liability issued to the taxpayer. Why is this important? Because as Michael mentioned, there are going to be notices that you may receive trying to collect debts, tax notices of payment due. Those are not all protestable notices. You can only protest a final tax liability notice. These include, but are not limited to, notices of deficiency, notices of tax liability, notices of penalty liability, and notices of claim denial. We also handle adverse decisions that are related to sales and property tax exemption status, so you may also protest those. Licensure, certificate of registration denials are also protestable. And there are other matters that fall solely under the jurisdiction of the Illinois Department of Revenue. Illinois Department of Revenue does have jurisdiction over cases and controversies where the tax liability, excluding penalty and interest, is less than $15,000. Or again, as I mentioned, protests of registration denials are limited to IDOR jurisdiction. So the $15,000 threshold is very important as well in terms of what the Office of Administrative Hearings will handle. You can move on to the next slide. And our Illinois Department of Revenue administrative law judges also preside over other agency hearings. So in addition to the revenue-based protests that we hear, our administrative law judges are also enabled under the intergovernmental agreements with external agencies to hear and preside over cases before the Illinois, or cases involving protests with the Illinois Gaming Board, Illinois Lottery, and Illinois Racing Board. Now, it's very important those requests for hearing are submitted directly to those respective agencies and are governed by their rules, and they all each have separate rules of procedure and statutory rules that govern those particular hearings, and those will be available on their respective web pages. Next slide, please. Our judges also hear retailer occupational tax and liquor license revocation cases. So that's also known as ROTs, and liquor license revocation cases that also will arise under unpaid tax liability that has been handled or is handled by our collections unit. So as Michael mentioned also, there are matters where we will have hearings on the spot, on the day of, should you be in collections for that type of tax liability. And those would be, again, handled by our administrative law judges. The liquor license regulation and other related matters are governed, for example, by the Illinois Liquor Control Commission. So those are handled with their own sets of rules as well. Next slide, please. So what cases do we not hear, right? Isn't that the question? We do not hear matters that fall under the jurisdiction of the Board of Appeals. And you will hear from Chairwoman Rebecca Kulikowskis, who will talk about the Board of Appeals jurisdiction in a little more detail, but I can just, as a teaser, let you know that offers in compromise, where the taxpayer seeks to reduce the amount owed based on financial, medical, or other demonstrable hardship, and requests for penalty or interest relief based on reasonable cause, are areas that are strictly handled by the Board of Appeals. Those cases would not be handled by administrative hearings. And that is because if a case has reached final tax liability, it needs to be protested with the Office of Administrative Hearings. If a taxpayer cannot pay due to other economic hardship, but the liability stands and there has not been a protest made, or that protest with the administrative hearings was not made in favor of the taxpayer, they are able to then take that to the Board of Appeals. Cases where the tax liability excluding penalty and interest is over $15,000 are handled by our Illinois Tax Tribunal. And there are deadlines associated with when those matters need to be filed. The tribunal operates completely separately and independently of the Illinois Department of Revenue and is governed by statute, which is listed 35 ILCS section 1-45, if you'd like to reference that. Next slide, please. So the other really important area where protests cannot be heard by administrative hearings are those that are made after the statutory deadline that is contained in the notice, and those are considered untimely. We cannot, under statute, hear those cases as a matter of course. However, there is an avenue for taxpayers who have either forgotten or just were not able to, for another reason, pay their tax liability timely. They may petition to have a late discretionary hearing. The late discretionary hearing can be requested only for protests that exceed the statutory deadline. And the decision is made solely within my discretion as Chief Administrative Law Judge. Now, I take those late discretionary hearings requests very seriously. When they do come in, I understand taxpayers run into various situations where they cannot pay on time. However, there are requirements, and my expectation is that when a late discretionary hearing request is made, it's that it's fully supported and that documentation is provided to show why that tax liability was not paid on time. Because again, we take statutory deadlines very seriously, and we want to apply the laws fairly to everyone. So we give opportunities where appropriate. The exception to the cases in terms of what cases can qualify for late discretionary hearing. Generally speaking, anything where there's a notice issued, notice of tax liability, notice of deficiency, a final and protestable notice. However, there is an exception to that. Claim denials, registration denials, reasonable cause denials, property tax exemption denials, and there are some other actions as well that are not going to fall under the jurisdiction of late discretionary hearing by me, and I cannot grant those. So, just simply put, I have limited discretion. I exercise it judiciously, but I exercise it fairly, and I want to make sure everyone has an opportunity to be heard on their protests. So if you would like to reference the authority that is given to me, it is in 86 Illinois Administrative Code, Chapter 1, Section 200-175. Thank you. Next slide. So now you're ready to request a hearing. You've decided whether you meet all the criteria, what area your case falls under, and then you say, I'm ready to request. Well, there are three ways. I'm going to start with the one I would like you to use, and that is the electronic mail filing request. We obviously get a slew of and many protest requests on a daily basis. My wonderful administrative staff handles the at least intake of those requests, and then I obviously review and we vet those to determine whether they should be opened and assigned. But if we receive the electronic mail option, which is via PDF, sent to our inbox, which is rev.adminhearings@illinois.gov. I'll repeat that, rev.adminhearings@illinois.gov, which is also on our webpage. We would receive those immediately. And we encourage taxpayers and practitioners alike to use this option because it just makes it so much easier to process and review those protest requests, especially when our staff is trying to manage multiple requests. It also reduces the time frame for which you would receive any sort of acknowledgement of receipt and docketing of that protest. And then the scheduling for initial status conference is also contingent upon how quickly and efficiently we can docket, receive the protest, docket the protest, and then schedule that protest for initial status. We also accept, however, mail copies as well to our Illinois Department of Revenue Administrative Hearings address, which is our Springfield location, which is MC-5-550-101 West Jefferson Street, P.O. Box 19014. And again, that's Springfield, 62794-9014. Again, this is all on the Illinois Department of Revenue webpage. And finally, hand delivery. Hand delivery is fine. We just want to make sure you have your protest received. Documents definitely can be dropped off at either our Springfield office, which is listed above, or our 555 West Monroe office, Suite 1100. And again, we're discouraging it because it takes longer. It has to route. So once you hand over a protest and your supporting documents, it has to now route through the agency to get to us and to get to our staff to make sure it gets processed efficiently. So we just encourage the electronic mail option as much as possible. Next slide, please. And then once you request and once the Office of Administrative Hearings receives the complete submission, and I emphasize complete because I would highly suggest anyone who's interested in requesting an administrative hearing to make sure all of your documents are together, whatever supporting documents along with the protest request form that is required are fully complete, signed, and any sort of associated documents such as the authorized power of attorney, which is imperative if you want someone to act on your behalf who is authorized either by a lawyer, a CPA, or whoever is going to be your authorized representative. We need that document to be also associated and submitted at the same time with that protest. So we would just encourage that once the complete submission is present and fully complete, we will then review and open your case, assuming every other deadline is met. So again, if there's statutory deadlines, we need to make sure those are met. Once every criteria has been satisfied, we will open the case and then schedule it for the initial status conference. You will then receive a notice of that initial status conference, and that will be mailed by regular US mail to the protesting taxpayer or their authorized POA. And again, we do the mail sending out of notices pursuant to statute. So that is our statutory requirement. And we also make sure that it is submitted again to the POA if that authorized POA is on file. Finally, if there's anything that we need additional, we will let you know, but we would hope that everything is concluded in the initial submission. Next slide, please. Now, again, all protests need to be, as I mentioned, on a specific form. We would ask that that be submitted on the AH4 form, which is the non-income tax form, or the EAR 14 form, which is the income tax form. And it's important because these protest and request for hearing forms are what our staff uses to determine what is the best way and rather the most appropriate way to open the case so that you are able to be efficiently notified of the hearing, or at least in the initial status that will be scheduled. The form should be completed in its entirety and again signed by the taxpayer. All the forms are available on our webpage. Again, that's www.tax.illinois.gov. And again, along with the protest should be the notice that you're protesting and any and all relevant information to dispute that you want to have considered for the dispute. And that means relevant financial documentation, any tax returns, anything you're using to support your basis for the protest. And that's particularly important if you are untimely and now you're requesting a late discretionary hearing, which would not require the forms that we're indicating. However, you still need to submit that relevant information. Next slide, please. And once the case is opened and scheduled for initial status conference, again, that is the first step in the proceeding. A litigator is now going to be assigned to your case. And that litigator, who is a member of the IDOR team who is representing the Department of Revenue. However, they are separate and independent of the Office of Administrative Hearings. That litigator will be assigned to represent the department and will contact you, the taxpayer, or POA, as the case may be, to the extent there's any need for additional documentation. Also, they will start the conversation around your protest and any discussions around whether there's a possibility to resolve your protest short of a full hearing. If the taxpayer wishes to have a representative but act on your behalf, however, you did not know ahead of time and did not submit a POA at that time, then it would be incumbent upon the taxpayer to then submit that authorized power of attorney form with their information, and that would need to go directly to the Office of Administrative Hearings. That has to be duly executed, and it has to be emailed to IDOR's first POA unit, which is the power of attorney unit, and then we would get it in turn and apply it to your protest. Please note, it's important that IDOR does not accept the federal power of attorney form because there is a separate form for federal IRS cases. Next slide, please. Now, once the Office of Administrative Hearings has decided that your case is submitted, you're properly submitted, opened, a docket number is assigned, and then both a judge and litigator will be assigned to the case. And the bottom line is all of the necessary parties and representatives have to be assigned to the case for the case to proceed. So we would need all staff to be assigned. Because the litigator is separately representing the interests of the department, those assignments are made by our legal services staff. So occasionally what will happen is you will submit a request for a hearing, it will be opened, and a judge will be assigned by myself. However, a litigator may not be immediately assigned to that case, but once that litigator is assigned, then the case is ready to proceed to an initial status conference. That would be then scheduled by Office of Administrative Hearings, date set, and then that's when the notice will be issued to the taxpayers. The initial status conference usually, and that is a big usually, aspirationally occurs approximately 3 to 4 weeks after the case is assigned to a judge and litigator. And I say that because, of course, we're dependent on the mail, we're dependent on our staff getting the properly getting the notices out, but then the mail has to ensure that you get it on a timely basis. So if there is ever any question, once your case is assigned and you're not receiving something, our staff will be able to assist with the situation in terms of why there is any delay. But this is the very, very first opportunity that you would have this initial status conference to appear before the judge. So it's also very important that when you receive the notice of initial status conference, that you look at the relevant information, you check to see who the litigator is, you contact the litigator should you have any questions, procedural questions, and then you make sure you're appearing on that very first initial status date. And again, post-pandemic, status conferences and hearings, things have changed, let's say that. Obviously, the pandemic made things very, very remote. Remote was the normal. Now it's post-pandemic. Status conferences are still held both remotely, but also by telephone. However, we are also very much open and able to have in-person status conferences and hearings. Typically, the status conferences are not held in person, but when we get to the point of your hearing being scheduled, we will accommodate any requests or needs to have an in-person hearing, which is also very much open to occurring at the Illinois Department of Revenue offices. The OAH personnel will make every effort to accommodate any taxpayer's request in that regard. Next slide, please. So what are the next steps again? There will be multiple status conferences, more than likely, before a case comes to the point of being ready to go to hearing. A final decision is ultimately issued by the judge in a written form. And we are encouraging, and by we, I mean our staff, our judges, are encouraging the parties to try to work to resolve cases. That means if they can resolve the case short of a hearing, they're saving themselves time, they may be saving themselves money and financial burden. And the bottom line is we're just trying to reach the fairest and most equitable result with the least burden on the taxpayer. So we would encourage, early and often conversations with the litigators in an effort to resolve the case. But there will be multiple status conferences to discuss where the parties are with respect to those discussions. Litigated cases are generally resolved through settlement and by agreement of the parties. But if they do not, we are absolutely ready and able and competent to hear those cases through a full evidentiary hearing. Next slide, please. Now, if the case is decided by a hearing, and that's important, and that means it goes through the entire process through to a full evidentiary hearing, or it could be sometimes parties submit papers, briefs in lieu of full evidentiary hearing. That hearing will be decided by the administrative law judge assigned, and a recommendation for disposition will be issued. That recommendation for disposition is not final until the director of revenue actually reviews and approves it. So you get multiple layers of checks and balances. The recommendation is actually reviewed first by myself, the chief administrative law judge, and to make sure that it is indeed correct and accurate and complete. And then that is submitted to the director of revenue for final approval. So we make sure that any recommendation that has been issued subject to and post full evidentiary hearing is finally reviewed and approved before it is distributed to the taxpayer. And that's important because the final recommendation for disposition, once approved, is fully appealable. And that is, it means it goes to circuit court and the circuit court of Cook County. So, and could be even appealed further if that is necessary. So those final recommendations are definitely important, and we take them seriously, and they are vetted. So we will issue those as soon as we are able after the finality of the hearing. If the case is decided by agreement of the parties, which means like a settlement and resolution, or sometimes even a withdrawal by the department or a withdrawal by the taxpayer, the protest may be something that the taxpayer determines is not appropriate after discussing things with the litigator. Once a final order is issued by the judge, it is still reviewed by the chief administrative law judge, myself, before it's issued. So every order and recommendation, every final order and recommendation is reviewed by myself and or the director before it is issued. That process, however, can take sometimes quite a while. It can take a very short period of time. 1 month is probably ambitious. Several months might be doable, but it depends on just how quickly we're processing things, but more importantly, how quickly the case could come to resolution by agreement of the parties. Depending on the nature and the complexity of the case, those orders would be final and then issued on the merits. And they, again, are subject to judicial review if they are issued as final recommendations under the administrative review law. If you have any questions at any time, we are here to assist. I think that's so important. Our staff is here to assist, and we definitely can be made, accessible through the rev.admin hearings at illinois.gov website, and we respond to that. I would like to say just also, I cannot reiterate the importance of the amnesty period. If you have a tax liability that is eligible for amnesty, and even if you have a case pending, and especially actually if you have a case pending with the Office of Administrative Hearings, or you're contemplating filing a protest because of a tax dispute, seriously consider amnesty and consider that that period ends November 17th, and any tax liabilities that are paid in that time period would be done so without exclusive of penalties and interest. So it's a great opportunity to get those tax liabilities that are eligible resolved. Next slide. Thank you so much for your time. Thank you so much for being here. It's important that you get this education.